The principle of special education legislation that I have chosen is due process under Individual with Disability Education Act. What is due process? Due process is a legal and formal way to resolve complaints. The Fifth and 14th Amendments to the United States Constitution guarantee legal due process. Both amendments protect an individual's rights and state that these rights cannot be taken away without legal proceedings. There are two types of due process considered within the 14th Amendment. The two types are substantive and procedure due process. Due process and special education. Two major court cases influence the need for legislation to ensure that the rights of children with disabilities and their parents are protected. The two court cases are Park versus Pennsylvania in 1972 and Mills versus Board of Education of District of Columbia in 1972. Both court cases were centered on denial of public education without due process. Due process and Education for All Handicapped Children Act. After the judicial decisions in the court cases Park and Mills, Congress in 1975 passed the Education for All Handicapped Children Act. Under this act, school districts were required to provide administrative procedures so that parents of disabled children could dispute decisions made about their children's education. Parents could seek judicial review only after they had exhausted all administrative efforts. Due process under the Individuals with Disability Education Act. Due process procedure for children with disabilities and their parents are outlined in the Individuals with Disabilities Education Act. These procedures are found in Section 1415 of the Act. Section 1415A requires that state education agency establish and maintain procedures to ensure procedural safeguard for the rights of parents and students. Then Section 1415B set forth the due process procedures in detail. The intent of due process under Individuals with Disability Education Act. The intent of due process under IDEAL is to safeguard the rights of children with disabilities to receive a free, appropriate public education. To comply with Section 303, Subpart E of the IDEAL, school districts have a procedural safeguard statement. For parents, due process protects their rights to have input into the educational program and placement of their child, and to have options in case of disagreement with the recommendations of the school district. For school district, due process offers recourse in case of parents' resistance with a request for evaluation or IEP team recommendations. Here I'm showing you a comparison between due process under IDEAL and Section 504. As you can see, there's not much difference in the due process under each one of these. But under Section 504, it requires the districts to provide a resolution session and a due process hearing. Under IDEAL, they don't necessarily have to go through the resolution sessions. Also under IDEAL, compensatory damages are possible. Due process organization. Under due process, under the ideal, there's a Tier 1 and a Tier 2. Under Tier 1, the state education agency or another state level agency is responsible for conducting due process hearing. In case of an appeal from a due process hearing decision, it goes directly to the court. But under Tier 2, the school district is responsible for conducting the due process hearings. In case of an appeal from a due process hearing, it goes to a state level review hearing before appealing to the court. Here I have outlined the due process procedures under ideal. Here I show Tier 1 and Tier 2. Tier 1 is highlighted, shown by the green arrows, and Tier 2 is shown by the blue arrows. Remember, Tier 1 is when the state education agency or another state agency oversee the due process hearing. Under Tier 2, that's when the school district oversee the due process hearing. The first thing that needs to be done on a due process procedure, a parent, or it could be an employee, but most of the time it's a parent or guardian, filed a due process complaint. And under this complaint, they are requesting a hearing. Now, if they decide to go on the Tier 1, there's a different route from Tier 2. And one thing I would like to mention, most of the complaints that are filed goes under Tier 1 as opposed to Tier 2. So once the parent or guardian file a complaint against the school district, if they go on Tier 1, then the state education agency will send a letter with contact information and timeline. Now, if they decide to go the Tier 2 route, then the local public education agency will send a letter with contact information and timeline. Now, what I'm going to do is just go ahead and go through Tier 1, and then I go back and go through Tier 2. So once the complaint been filed under Tier 1, the state education agency will take a look at the complaint and send a letter to the local school district and to the parent with contact information and a timeline. Then under Tier 1, the case would then, a due process hearing will be scheduled. Under the due process hearing, a hearing officer will hear the evidence and mail hearing decision within 45 calendar days from the beginning of the timeline. Now, this 45 calendar days is outlined in the ideal. And the hearing officer's decision can be challenged. If the parents are not satisfied with the hearing officer's decision, they can appeal this case to the state or federal courts within 90 days of the hearing officer's decision. Now, if the case go through Tier 2, of course, the parent or guardian will file a complaint, and then the public education agency will handle the case and will send a letter with contact information and timeline to the school and as well as to the parent or guardian. Now, the school has 10 calendar days to respond to the complaint. Now, also under Tier 2, before a resolution meeting is held, a remediation can be held between the parties to try to resolve the issue before it goes to a resolution meeting. But if a mediation is not held, then a resolution meeting is held within 15 days of receiving the complaint. If no agreement is reached in the resolution meeting, a due process hearing is held. Then it goes to the due process hearing, and the hearing officer will hear evidence and he will mail his decision within 45 calendar days from the beginning of the timeline. And then again, if the parent or guardians are not satisfied with the decision of the hearing officer, they can challenge it in state or federal court. Why due process? Due process is beneficial to children with disability. As stated, due process ensures that children with disability receive free, appropriate public education. Due process is in place to safeguard rights for a child with disability, his parents, and the school district. Because due process is available for all parties, it's established and set the tone for how evaluations should be performed. Individualized education plan meetings are held, are conducted, and decisions are rendered. Due process focus on the child's education, according to Lee, and not on the school's procedures or technical violations. For teachers, due process can serve as a warning regarding the implementation of the individual education plan. Parents, non-school district want to spend time and money litigating a special education case because of potential negative consequences. So it's important for public education agency to adhere to all requirements under the Individual with Disability Education Act. These are the references, and that's it.